So it's completely up to you. Otherwise, these are your conditions. $500 fine probated, regular reporting by Zoom or in person, 2 years deferred adjudication, 100 hours of community service restitution. The court is going to call 2026 CR 000504, State versus first name. I'm sorry? Milani Williams. Could I have parties announced?
Kira Falcone for defense.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I have.
All right, the court will find that the state is in compliance with discovery, and for the record, Attorney Hague is listed as the attorney. I know you work in the office, but do you have any objections to this attorney standing in? Yes, they do. All right, you're gonna have to speak up so everybody can hear, mainly me and the court reporter, you understand? You have to say yes or no. Head shaking, nobody knows what that is. So the court is finding that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to proceed on the lesser included offense of attempted assault cases.
Any objection?
No, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? State is proceeding on the lesser included offense of attempted assault of a peace officer, which is a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow the plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine? Okay, are you able to speak up? Why not? All right, so you're gonna have to talk louder so the court reporter can hear and so I can hear. Do you understand? How old are you?
18.
I'm sorry, how?
18.
All right, so you're gonna have to speak up. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Williams, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Okay, off the record for a moment. Cindy, let me know when you're able to unwrap the cough drop. Got it. All right, thank you. Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, state is proceeding on the lesser included offense. They're asking that you have a $500 fine and they're recommending deferred adjudication. Did you understand that to be? Yes.
I meant to probate the fine, Judge.
Okay,
I apologize.
no problem. Any objection to the court writing in that the fine is probated?
No, Your Honor.
Thank you.
All right. And there's a $500 fine that's probated. Did you understand that to be your plea? State defense?
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be 100 hours community service restitution, the healthy relationships and anger prevention and stress education. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yeah.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
State offer seats exhibit 1 in all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client? All right, who is Andres Vasquez? I'm sorry? All right, is that the person who's in the stipulations with the relationship issues?
Yes, and that case was dismissed, Your Honor.
All right, are you all still together? All right, are you in school? That's
No.
either yes or no. What are you doing with your life? I'm sorry, what? All right, do you have employment? So how do you spend your day? All right, so, and when you say you just graduated, when? What month? June. So what are your plans? You have no plans for your future? All right, have you signed up for the military? Have you looked into that? So when are you planning on doing that?
Your Honor, if I may, her twin sister is already enlisted. She wanted to join her, but this case has prevented her from being able to properly do so. So there's been kind of adjustment plans that they've tried to.
Oh, well, I will tell you this. If you end up signing up into the military, your attorney can come here and file a motion for early term. And if you bring me proof that you have actually enlisted, then the early termination will be granted.
Thank you, Judge.
So if you get that done tomorrow and you come in here before the end of the week, legally, I can terminate you and I will. So it's completely up to you. Otherwise, these are your conditions. $500 fine probated, regular reporting by Zoom or in person, 2 years deferred adjudication, 100 hours of community service restitution. I'm going to order anger management. Once the anger management is completed, then 25 of the community service hours will be deemed satisfied.
Thank you, Judge.
And I'm going to order healthy relationships. Once the healthy relationships is completed, 75 hours of the community service will be deemed satisfied. There's to be proof of employment or a higher level education, enrollment, or an enrollment in the military, if that's what you want to do. And I'm just putting this here so that I will remember, although my mind is a steel trap, I'll still remember it, that you are thinking of enrolling in the military. If you decide to enroll in the military, I'll grant the motion for early term.
Thank you, Judge.
Okay, and also Ms. Abrams, or an enrollment in trade school within 30 days. So you're either going to be employed, you're either going to be seeking a higher level of education or in somebody's trade school, or either join the military. Those are your options, and that needs to be done within 30 days. And there's to be no employment as a home health care provider or with minors. And there's to be no contact with Mr. Andres Vasquez. That's Andres Vasquez. And field visits 1 time per month for 3 months. Probation, is there anything else? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney, did you understand it and did you sign it?
Yeah.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. If you decide to join the military, you're gonna have to speak up. You understand? All right. Go in a respectful way. But the drill sergeants will be shouting in your face, okay? Good luck.
Thank you, Judge. May we be excused?
Yes.
Milani Williams appears before the court on a reduced charge of attempted assault of a peace officer, a degree felony, after the state agrees to proceed on a lesser included offense and recommend deferred adjudication. With guilt not formally entered and a plea bargain already in place, the hearing's real function shifts from adjudicating fault to determining whether this defendant has any structure capable of preventing a repeat appearance. Judge Boyd's line of questioning about school, employment, and daily routine is not procedural filler. She is testing whether deferred adjudication, a second chance predicated on stability, has anything to attach itself to. The defendant's halting, minimal answers reveal an absence of plan rather than active defiance, which matters because it reframes the risk calculus. This isn't a case requiring incapacitation but intervention. The sentence reflects that diagnosis directly. Community service tied to anger management and healthy relationships courses addresses the behavioral root rather than merely imposing a penalty. The employment or education requirement within 30 days forces the structure that was missing. The no-contact order with Vasquez removes the relational pattern connected to prior dismissed allegations. Even the offer to expedite termination upon military enlistment shows the court building an off-ramp rather than simply enforcing conditions. The hearing ultimately demonstrates a judicial philosophy centered on redirection over punishment when a defendant's failure is one of drift rather than danger. Judge Boyd's approach treats deferred adjudication not as leniency, but as a structured bet on accountability.